5 seconds to go. Start. Of course, when we say this, we must not be understood to mean that whenever there is delay in arresting the detainee pursuant to the order of detention, the subjective satisfaction of the detaining authority must be held to be not genuine or colorable. Each case must depend on its own peculiar facts and circumstances. The detaining authority may have a reasonable explanation for the delay, and that might be sufficient to dispel the inference that its satisfaction was not genuine. Having held as above, Bhagwati judge, as the learned Chief Justice then was, pointed out that if there is any delay in arresting the detainee pursuant to the order of detention, which is prima facie unreasonable, the state must give reasons explaining the delay. A similar contention was raised in Suresh Mehato versus the District Magistrate Bardwan and others 1975 3 SCC 554 on the basis of the dictum laid down in two decisions of this court contending that the delay of the arrest of the detainee in that case showed that the detaining authority was not really and genuinely satisfied as regards the necessity for detention of the detainee, for otherwise he would have tried to secure the arrest of the detainee promptly and not left him free to carry on his nefarious activities. Bhagwati Judge, as the learned Chief Justice then was, while dealing with this submission, made the following observation. Now, there can be no doubt, and the law on this point must be regarded as well settled by these two decisions that if there is unreasonable delay between the date of the order of detention and the date of arrest of the detainee, such delay, unless satisfactorily explained, would throw considerable doubt on the genuineness of the subjective satisfaction of the district magistrate, and it would be a legitimate inference to draw that the district magistrate was not really and genuinely satisfied as regards the necessity for detaining the petitioner. Chinnappa Reddy judge, speaking for the bench in Bhavarlal versus State of Tamil Nadu 1979 1 SCC 465, has explained as follows. It is further true that there must be a live and proximate link between the grounds of detention alleged by the detaining authority and the avowed purpose of detention, namely the prevention of smuggling activities. We may, in appropriate cases, assume that the link is snapped if there is a long and unexplained delay between the date of the order of detention and the arrest of the detainee. In such a case, we may strike down an order of detention unless the grounds indicate a fresh application of the mind of the detaining authority to the new situation and the changed circumstances. But where the delay is not only adequately explained but is found to be the result of the recalcitrant or refractory conduct of the detainee in evading arrest, there is warrant to consider the link not snapped but strengthened. Stop.